can get. Committee will come to order. Without objection, chair is authorized to declare recess at any time pursuant to Committee Rule 2, House Rule 11, Clause 2. The chairman may postpone further proceedings today on the question of approving any measure or matter or adopting an amendment for which a recorded vote is ordered. The chair now recognizes the gentleman from Wisconsin for the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Pursuant to notice, I call up H.R. 4250, the Protecting Reporters from Exploitative, tough word, man, we got to come up with a better title to have to say that, State Spying Act for purposes of markup, and move that the committee report it favorably to the House. The clerk will report the bill.
H.R. 4250 to maintain the free flow.
Without objection, the bill will be considered as read, open for amendment at any point. The chair now recognizes the gentleman from California, the primary sponsor of the legislation, Mr. Kiley, for an opening statement.
Thank you, Mr. Chair. H.R. 4250 is a bipartisan bill that protects journalists from government overreach. What it does is prohibit the federal government from compelling a journalist to disclose documents, communications, or other information obtained as part of the journalist's job gathering and informing the public of information. This is a very important protection for freedom of the press, which of course is at the heart of the First Amendment and of representative government itself. Almost every state has this protection in some form. 32 states and DC have statutory shield laws, and a total of 49 states have either a statutory or common law reporter's privilege. But there is no such protection under federal law. This bill changes that. Robust protections for a free press are important for many reasons, including exposing government abuses, waste, fraud, and encroachments on personal freedom. And that requires being able to pursue the truth without fear of government entanglement or intimidation. Across administrations, we've seen the unjust targeting of journalists using compulsory process to obtain information from them about their sources, which has a chilling effect on the ability to hold the government accountable. Over the years, versions of this bill have received broad bipartisan support from across the political spectrum, and the time has come to get it passed and sign this important protection into law. I urge support and yield back.
Gentleman yields back. The chair now recognizes the ranking member for an opening statement.
Thank you, Mr. Chairman. Mr. Chairman, H.R. 4250, the Protect Reporters from Exploitative State Spying Act, or PRESS Act, would ensure that the press can engage in effective journalism while reducing the risk of putting themselves or their confidential sources, upon whom they often rely to bring critical stories to the public's attention, in legal jeopardy. Specifically, the PRESS Act would create a strong but qualified federal statutory privilege that protects journalists from being compelled by the federal government to reveal confidential sources and information. The bill also allows the government to defeat this privilege under certain circumstances, such as where a court determines that the disclosure is necessary to prevent or identify any perpetrator of an act of terrorism, or to prevent the threat of imminent violence, significant bodily harm, or death, and then only after the journalist is provided notice and an opportunity to be heard before the court. In addition, the bill includes important protections against the federal government compelling an electronic service provider from disclosing a journalist's information, subject to certain exceptions, and it contains a rule of construction that prohibits the bill from being construed to apply in certain types of cases. H.R. 4250 is necessary and long overdue legislation. Over the past several decades, Democratic and Republican presidential administrations have attempted to crack down on leaks of classified information to media outlets, and these investigations have included efforts to obtain journalist records. In 2021, the Washington Post, the New York Times, and CNN reported that the Department of Justice under the Trump administration sought the information and records of their reporters. Previously, during the Obama administration, the department reportedly searched Fox News reporter Jeffrey Rosen's emails and even listed him as a co-conspirator in an Espionage Act case against the source of leaked information. These and other recent episodes further illustrate the need for stronger federal protections for journalists and their sources. Indeed, one of the most critical roles that the free press plays in our democracy is informing the public on the functioning of government and the policymaking process, including allegations of wrongdoing or incompetence. Yet the press's ability to carry out this role would be seriously eroded if a reporter could not obtain complete and accurate information about such wrongdoing or incompetence by assuring confidential sources of their anonymity. H.R. 4250 would protect a journalist's ability to bring these important stories to the public's attention, stories which almost always hinge on protecting the identity of confidential sources without unwarranted interference by the federal government. The lack of a federal press shield law is quite striking, given the broad and bipartisan support for such laws. 41 states and the District of Columbia have enacted press shield laws or otherwise afford similar privileges through their state constitutions and common law. Here in Congress, there is longstanding and bipartisan support for a federal shield law. For example, former Vice President Mike Pence, when he was a member of this committee back in 2005, introduced the Free Flow of Information Act, which was very similar in concept to H.R. 4250. Both that legislation and the Press Act have each passed the House numerous times, including in the last session, and I am hopeful that the Senate will join the House in support of this important legislation. I am encouraged that although stark differences among members of this committee remain, the Press Act continues to enjoy bipartisan support. I thank Chairman Jordan for bringing this legislation before the committee. I urge my colleagues to support it, and I yield back the balance of my time.
Gentleman yields back. I would just add, I think I've co-sponsored this legislation in different Congresses with Mr. Liu, with Mr. Raskin, and I think with the ranking member. Yeah, so great piece of legislation. Who seeks recognition on the legislation?
Mr. Chairman,
The gentlelady from California is recognized.
I move to strike the last word, and I will not speak for 5 minutes, but I just want to say how grateful I am that this bill is before us for markup. I remember that when Vice President Pence was a member of this body, I was the principal co-sponsor with him on that bill. So this has been a bipartisan effort for many, many years, and I'm hoping that this time we'll get a chance not only to move it out of committee, but to get it to the President's desk for signature. So with that, I want to note my enthusiastic support, and I yield back.
Gentlelady yields back. All right, we can vote, I think. The question is on favorably reporting the bill. All those in favor say aye. Aye. Those opposed, no. The ayes have it, and the bill is ordered to be reported favorably to the House. Members will have the gentleman from Arizona requested a recorded vote. The clerk will call the roll.
Mr. Jordan?
Yes.
Mr. Jordan votes yes. Mr. Issa? Mr. Buck? Mr. Gates? Mr. Johnson of Louisiana?
I got enough here. I think we do.
Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock? Mr. Tiffany? Mr. Tiffany votes aye. Mr. Massey? Mr. Roy? Mr. Bishop? Mr. Bishop votes aye. Ms. Sparks? Mr. Fitzgerald? Mr. Bentz? Mr. Klein? Mr. Klein votes aye. Mr. Gooden? Mr. Van Drew? Mr. Nels? Mr. Moore? Mr. Moore votes aye. Mr. Kiley? Mr. Kiley votes aye. Ms. Hageman? Mr. Moran? Mr. Moran votes aye. Ms. Lee? Ms. Lee votes aye. Mr. Hunt? Mr. Fry? Mr. Nadler? Mr. Nadler votes aye. Ms. Lofgren? Ms. Lofgren votes aye. Ms. Jackson-Lee? Mr. Cohen? Mr. Johnson of Georgia? Mr. Schiff? Mr. Schiff votes aye. Mr. Swalwell? Mr. Liu? Ms. Jayapal? Ms. Jayapal votes aye. Mr. Correa? Mr. Correa votes aye. Ms. Scanlon? Mr. Neguse? Ms. McBath? Ms. Dean? Ms. Dean votes aye. Ms. Escobar? Ms. Escobar votes aye. Ms. Ross? Aye. Ms. Ross votes aye. Ms. Bush? Mr. Ivy?
Aye.
Mr. Ivy votes aye. Ms. Ballant? Aye. Ms. Ballant votes aye.
Mr. Johnson?
Mr. Johnson of Louisiana votes yes.
Ms. Scanlon?
Ms. Scanlon votes aye.
working on getting our folks here. We just need two more, right? Yeah. Is someone working on getting Daryl here? Tyler? Is Daryl here? Gentleman from California?
Mr. Chairman, I'd like to be a yes, please.
All right.
Mr. Isa votes yes.
We just need one more.
We need one for 23.
Pardon? Just gotta get a quorum here.
Yeah. We've been asked very nicely to vote on everything. We need to get the 23.
I hear you. Who is for rule? Andy, I don't know why, because I was fine doing them by voice, but Mr. Biggs asked for it.
Doesn't matter. Yeah, I better. Yeah, one body, don't care who it is. He voted.
Ms. Hageman? Ms. Hageman votes yes.
Clerk will report.
Mr. Chairman, there are 23 ayes and 0 noes.
The ayes have it, and the bill is ordered to be reported favorably to the House. Members will have 2 days to submit views. Without objection, the staff is authorized to make technical and conforming changes. Pursuant to notice, I now call up H.R. 4639, the Fourth Amendment is Not for Sale Act, for purposes of markup, and move that the committee report it favorably to the House. The clerk will report the bill.
H.R. 4639 to amend Section 270.
Without objection, the bill will be considered as read and open for amendment at any point. The chair recognizes the gentleman from Arizona, Mr. Biggs, for an opening statement.
Thank you, Mr. Chairman. The Fourth Amendment guarantees all Americans the right to be free of unreasonable government searches and seizures. Currently, the laws governing the Fourth Amendment are not necessarily being applied in certain digital contexts, and courts do not consider searches of database that have been acquired through purchase as requiring warrants. The key legislation in this space is the Electronic Communications Privacy Act, which was written in 1986 and did not take into account all the advances in digital communication that have occurred since that time. It is therefore necessary to do our job to update key tenets of privacy law. This bill would prevent federal agencies' further abuse of this loophole. Rather than obtaining a warrant, as they would be required to for a wiretap of a phone call, government agencies such as the FBI, IRS, DEA, DHS, and others have begun buying data from data brokers to increase large amounts of Americans' data and then search them with no warrant. In one example, the CDC paid $420,000 to purchase location data during the pandemic to determine whether Americans were going to church, visiting their neighbors, or otherwise abiding by the government's arbitrary social distancing laws. This bill will prohibit the government's purchase of this data that includes private personal information like location information, online data, health information, etc. It will also require the government to get a court order to force data brokers to disclose data, treating these cases more like traditional phone wiretaps. The committee has in recent years passed major reforms to overhaul the ECPA, but those bills have never made it into law. It's time to finally move major legislation to protect privacy. And this bill is exactly the type of legislation needed to rein in the federal government and protect the privacy rights of Americans. Data brokers are selling Americans' personal information to law enforcement and intelligence agencies, which are then being searched without warrants and without oversight. In contrast to strict rules that prevent phone companies and social media sites from selling such information to the government. This is Congress's job to update the law and fill in gaps that arise over time. We must act today to pass this bill and end the government's ability to avoid the Fourth Amendment by purchasing your highly sensitive information from data brokers and then ultimately using it against you. The Fourth Amendment is Not for Sale Act would close this legal loophole and is a critical step in limiting the federal government's warrantless surveillance of Americans. I am appreciative of those on the other side of the aisle who are co-sponsoring this important piece of legislation. I look forward to bipartisan support for this now and on the floor, and I appreciate everyone who's worked on this. And I ask again that all of us come together to fortify the Fourth Amendment and support this legislation. And before I yield back, Mr. Chairman, I just want to point out a few other things. The U.S. government buys data on American with little oversight, report finds. So I have a series of articles I would like to submit for the record. One is CDC tracked millions of phones to see if Americans followed COVID lockdown orders. Another is a letter by Senator Ron Johnson to Dr. Walensky, director of the CDC. The FBI an article titled, "The FBI just admitted it bought U.S. location data." I'd like to submit those for the record, please. Thank you. Yield back.
Gentleman yields back. The chair now recognizes the gentleman from New York, the ranking member, Mr. Nadler, for an opening statement.
Thank you, Mr. Chairman. Mr. Chairman, H.R. 4639, the Fourth Amendment is Not for Sale Act, is strong bipartisan legislation that would prevent government overreach by prohibiting the warrantless purchase of customer data. We are living through an information technology revolution. Email, social media, smartphones, and laptops have transformed our lives over the last 20 years. This technology is not going anywhere, and we do not want it to. But these incredible new technologies have also raised privacy concerns that could not have been imagined when the laws governing them were put into place. One of the chief privacy concerns behind this new technology involves the sale and acquisition of data. When you do anything that involves the internet, you leave a breadcrumb trail of data behind. This generates a substantial amount of personal information that most of us would like to keep private. Certainly, we would like to keep it private from companies, but we especially would like to keep our online habits private from our own government. Every person sitting in this room today likely has a cell phone with them. Our lives have moved online, and our digital footprints are constantly being swept up by internet companies who can sell the information for commercial use in micro-targeted advertisements or the compilation of complex digital profiles. Dating websites, mobile prayer apps, and other companies that deal in our personally sensitive information are often free to collect and sell data on our precise location, who we love, or how we worship. And although some companies claim to sell only de-identified data or to never sell it to the government, experts agree that there's just one problem. These claims are not remotely true. Data brokers can re-identify anonymous data, knowing whose data they are looking at, and in many cases, a person's location in real time, with just a few pieces of so-called de-identified data. This loss of anonymity is a problem for all kinds of reasons, but it is especially troubling when that data is being bought and used by the FBI and other law enforcement agencies. While we do not have access to the full picture of law enforcement data access, some government contracts can give us a sense of scale. ICE, DEA, and the FBI, among other agencies, all contract with a data broker that sources location data from over 80,000 apps and is so precise that officers can track individuals within specific homes and businesses. Government agents use data products to track suspects, facilitate deportations, and even monitor for potential crimes. Even more worryingly, integrated personal profiles offered by data brokers are also used to supplement controversial predictive policing technologies and surveillance mechanisms, such as facial recognition software and gunshot detection, posing further risks to our civil rights and civil liberties. We have the Fourth Amendment for a reason. If law enforcement wants to gather information about you, they should need a warrant for that. They should have to go to a judge and explain why there is probable cause and why they need to know this information. But when federal law enforcement purchases this data, they can bypass our judicial system entirely. They just need to go to the cloud. Our current state of affairs is clearly not what our founders intended. Our right to privacy is being abrogated every day by those whose job it is to keep us safe. The Fourth Amendment is not for sale act would change that. Under this legislation, government agencies would no longer be able to exchange anything of value for customer data. Moreover, it would also prohibit law enforcement agencies from seeking to circumvent these requirements by stopping third-party disclosure of data to law enforcement and interagency data sharing, among other provisions. I was proud to introduce this legislation in the last Congress, and I am pleased to be the lead Democratic co-sponsor this Congress. I thank the chairman for bringing it up before the committee. I urge all members to support it, and I yield back the balance of my time.
Gentleman yields back. I would just add, if we remember from the hearing last week when the director of the FBI was asked, I believe by Ms. Jayapal and I think a second colleague of ours from the Democrat side, about this very issue. Is the FBI purchasing Americans' data from brokers and private data? His response on both occasions, if I remember correctly, was, I'll have to get back with you and give you a briefing. So this is as timely as it comes. This is a great piece of legislation, and I appreciate the bipartisan support we are getting for it. Who seeks recognition?
I seek recognition.
The gentleman from Florida, and then the gentlelady from Washington.
Thank you, Mr. Chairman. I'm in strong support of this legislation, and it was Ms. Lofgren who asked the question about whether or not this was being utilized as a mechanism to do an end run around the Fourth Amendment. And what I believe Director Wray said in response was that it was really complicated. Yeah. And so it doesn't really seem that complicated to me. You either have probable cause and get a warrant, or you don't. And if you don't, you shouldn't be able to use these data brokers to violate the constitutional rights of our fellow Americans. So I'm glad we're bringing the bill forward, and I yield back.
Gentlelady from Washington.
Thank you, Mr. Chairman, Chairman Jordan, and Ranking Member Nadler. I appreciate your swift work to bring this important bill forward for our consideration. I continue to be deeply concerned about the intelligence community's purchase of Americans' data using this data broker loophole. That's exactly why I did question FBI Director Wray last week on transparency, and I'm afraid I didn't get any clear answers. Congress made it clear when it passed the Electronic Communications Privacy Act in 1986 that it did not want big tech selling data that it collects on Americans to the United States government, and that the government needs to get a warrant to secure this type of information. The Supreme Court made it clear in its landmark 2018 ruling in Carpenter that it is a violation of the Fourth Amendment for the government to access historical location data without a warrant. Specifically, the Supreme Court ruled in Carpenter that in general, the government needs to secure a warrant to get over 7 days of people's cell phone location data. Yet, the intelligence community is using the data broker loophole to justify its purchase of massive amounts of Americans' data. We live in a time where our phones track everything that we do, so we're talking about information about everything from medical and mental health, location, internet activity, and more. Data brokers have tried to defend their collection and sale of Americans' data, claiming that the data they sell is made anonymous. But even the Office of the Director of National Intelligence admits that it's frequently possible to identify individuals through this data. The intelligence community's practice of buying significant amounts of Americans' data is outrageous, it's unacceptable, and it's dangerous. It is a threat to Americans' essential right to privacy and an end run around the Fourth Amendment. Don't just take my word for it. The declassified report from the Office of the Director of National Intelligence said that commercially available information, quote, has increasingly important risks and implications for U.S. person privacy and civil liberties, as commercially available information can reveal sensitive and intimate information about individuals, end quote. It also says that this data, again a quote, could be used to cause harm to an individual's reputation, emotional well-being, or physical safety. The ODNI report goes on to say that the IC, quote, does not currently have sufficient visibility into its own acquisition and use of commercially available information across its 18 elements. It also notes that in the wrong hands, sensitive insights gained through this commercially available information could facilitate blackmail, stalking, harassment, and public shaming. The idea that millions of taxpayer dollars are going towards the IC purchasing data on Americans to spy on them, to warrantlessly get information that could harm Americans, is outrageous. We cannot tolerate this, and it must stop now. Congress has been clear, and so have the courts. If the government wants to get private information and track our location, it must obtain a warrant from a court. The government must not be allowed to continue making an end run around the Fourth Amendment by buying Americans' data from data brokers. The Fourth Amendment is Not for Sale Act, which I am proud to co-sponsor, would end this practice, and I hope we can have a bipartisan vote on the floor and send this bill to the President's desk. I urge my colleagues to vote yes, and I yield back.
Gentlelady yields back.
Mr. Chairman,
Gentlelady from California is recognized. Ms. Lofgren.
I move to strike the last word.
Gentlelady is recognized.
I'm very happy that we're marking up this bill today. I did want to note, however, that even though this is an important step forward for privacy, it is not all that we need to do. Many of us have discussed the need to address privacy issues when relative to Section 702. I want to let people know, and I've been talking to members of the committee on both sides of the aisle, that we're trying to put together a more significant piece of legislation that could also incorporate this measure that would address a whole variety of trespasses against privacy of Americans. And the fact that we're doing this now would not preclude that effort. I would just like to note that we were here with the director of the FBI. I did ask the question. The director said that it was complicated, which I didn't think it was, and that they would reach out to us. And we're still waiting for the outreach from the FBI. I just thought I would report that they never did follow up with the explanation of what they purported to claim was complicated. So with that, I certainly support this measure. I think I'm a co-sponsor, but I'm hoping that we will be able to mark up something that goes even farther than this later in this year. And I'm working with the Senate so that we will have bipartisan and bicameral support so that this measure can actually become law. With that, Mr. Chairman, I yield back.
The gentlelady yields back. We appreciate that. I'm glad you're working with bipartisan, bicameral, because we're doing the same thing. And I think there's agreement on our side, too, that 702 needs to be dramatically changed. So we appreciate that and look forward to that effort combining with this. The gentlelady from Pennsylvania is recognized.
Yes, Mr. Chairman, I'd move to strike the last one.
Gentlelady is recognized.
Thank you. Data brokers do gather intensely personal information such as location data and search history from Americans. And with the rise of healthcare apps, which are convenient and provide new opportunities for people to manage their own healthcare, there are also fresh opportunities for intrusion into people's personal affairs. We do know that data gathered by brokers have been used to circumvent the Fourth Amendment, out LGBTQ Americans, stalk and harass individuals, and jeopardize the safety of people who visit abortion clinics for health care. So I absolutely support the bill that we're considering here today. The Fourth Amendment is Not for Sale Act, and the principles behind it are why I introduced the Data and Health Location Protection Act to rein in data brokers' unscrupulous practice of trading on Americans' vulnerabilities. As data brokers remain free from federal regulation to collect highly personal data from seemingly innocuous sources and sell it to the highest possible bidder, it's beyond time to regulate the industry. And in the post-Roe, post-Dobbs world, there are fresh concerns about how that very personal data could be weaponized. So I do support this bill, and I yield back.
Gentlelady yields back. Gentlelady from Texas.
I move to strike the last word. And as I begin, Mr. Chairman, I was unavoidably detained on the Press Act, and I just want to add a few comments because I think the overall legislative approach that we're taking today is clearly representative of the oversaturation of data as well as the oversaturation of vulnerability of Americans in losing their data. I just take a simple example that it may not be a direct corollary to the Press Act or protecting the Fourth Amendment, but we've seen over the last decade the enormous in essence, loss of data, private data, personnel records in the federal government, hacking, banking records gone, medical records gone. So we know that overall, we are particularly vulnerable to the enormous amount of data and who can access it. So in particular, I'm very interested in making mention of my support for the Press Act, because this bill would prohibit the federal government from compelling journalists and providers of telecommunication services to disclose certain protected information except in limited circumstances, such as to prevent terrorism or imminent violence. And I think the key to this is the bill's effort at protecting from disclosure any information identifying a source, as well as any records, contents of a communication, documents, or information obtained or created by journalists in the course of their work, which is their ultimate protection of the First Amendment, and certainly their ultimate protection providing Americans with the absolute truth, which is the core values of our Constitution, that we are a nation that allows this kind of open transparency. So I ask unanimous consent, Mr. Chairman, on my statement on that bill to be put in the record, and that my vote may be recorded as aye in the appropriate place of the record.
Without objection.
I now rise to discuss my very strong support of the Fourth Amendment is Not for Sale Act, and particularly to put us in the context, as I said, of the loss of information, but also as we approach the overwhelming takeover, if you will, of artificial intelligence. There are all manner of ways that the Fourth Amendment may be in jeopardy. And so I would just simply like to take note of the fact that the collection and retention of personal data by cell phone providers, mobile application developers, web hosting platforms, and social media companies, among others, has become an unavoidable backdrop to modern life. In providing this legislation, we respond to Chief Justice Roberts' writing in 2014 decision, Riley versus California, that calls cell phones, among others, such a pervasive and insistent part of daily life that the proverbial visitor from Mars might conclude that they were an important feature of human anatomy. 60% of surveyed adults in the United States told the Pew Research that they do not think it's possible to go through daily life without having their data collected. So the Fourth Amendment had its confines in the Constitution. I believe the Constitution is a living, breathing document, and that means we must always be diligent in protecting the Fourth Amendment of unreasonable search and seizure. Most people thought of a knock on the door and taking your items out of your house, your car, or otherwise, place of business. Now we don't have to have anyone move anywhere to intrude upon your private life. I think this legislation, along with our recognition that we're moving more and more to technology and something called AI, is extremely important. And as I noted in a comment in our memo provided here, data is often called the oil of the 21st century. What will it be called in the 22nd century? And I rise to support the Protect the Fourth Amendment Act, and ask unanimous consent to join all three of the bills today as a co-sponsor if I'm not on. With that, Mr. Chairman, I yield back.
Gentlelady yields back. Who seeks recognition? Reporting quorum being present, the question is now on favorably reporting the bill. All those in favor say aye. Aye. Those opposed, no. The ayes have it, and the bill is ordered to be reported favorably to the House. Members will have 2 days to submit views. Gentleman from Louisiana requests a recorded vote. The clerk will call the roll.
Mr. Jordan?
Yes.
Mr. Jordan votes yes. Mr. Issa? Yes. Mr. Issa votes yes. Mr. Buck? Mr. Gates? Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes aye. Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock? Mr. McClintock votes aye. Mr. Tiffany? Mr. Tiffany votes aye. Mr. Massey? Mr. Roy? Mr. Bishop? Mr. Bishop votes aye. Ms. Spartz? Ms. Spartz votes yes. Mr. Fitzgerald? Mr. Benz? Mr. Klein? Mr. Klein votes aye. Mr. Gooden? Mr. Van Drew? Mr. Nels? Mr. Moore? Mr. Moore votes yes. Mr. Kiley? Mr. Kiley votes aye. Ms. Hageman? Ms. Hageman votes yes. Mr. Moran? Mr. Moran votes yes. Ms. Lee? Ms. Lee votes aye. Mr. Hunt? Mr. Fry? Mr. Fry votes aye. Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren? Aye. Ms. Lofgren votes aye. Ms. Jackson Lee?
Aye.
Ms. Jackson Lee votes aye. Mr. Cohen? Mr. Cohen votes aye. Mr. Johnson of Georgia? Present. Mr. Johnson of Georgia votes present. Mr. Schiff? Mr. Schiff votes aye. Mr. Swalwell? Mr. Swalwell votes aye. Mr. Liu? Ms. Jayapal? Ms. Jayapal votes aye. Mr. Correa? Mr. Correa votes aye. Ms. Scanlon? Ms. Scanlon votes aye. Mr. Neguse? Ms. McBath? Ms. Dean? Ms. Dean votes aye. Ms. Escobar? Ms. Escobar votes aye. Ms. Ross? Ms. Ross votes aye. Ms. Bush? Mr. Ivy?
Aye.
Mr. Ivy votes aye. Ms. Ballant? Aye. Ms. Ballant votes aye.
Gentleman from Florida.
Mr. Gates votes aye.
Clerk will report.
Mr. Chairman, there are 30 ayes, 0 noes, and 1 present.
The ayes have it, and the bill is ordered to be reported favorably to the House. Members will have 2 days to submit views. Without objection, the staff is authorized to make technical and conforming changes. Pursuant to notice, we call up H.R. 1631, the Protecting and Enhancing Public Access to Codes Act, for purposes of markup, and move that the committee report it favorably to the House. The clerk will report the bill.
H.R.
Without
1631.
objection, the bill will be considered as read and open for amendment at any point. The chair now recognizes the gentleman from California, Mr. Issa, for an opening statement.
Thank you, Mr. Chairman. I come by this bill honestly. Mr. Deutsch and I, with him as the lead, introduced it in the last Congress and wasn't able to be marked up and made law. But so it comes again, but it doesn't come again because we can wait forever. It comes because there is a clear need to strike a balance between copyrighted material that ends up being in codes or in laws, if you will, of the United States, and the rights of the copyright holder. Clearly, we understand that if you must have information in order to comply with regulations/laws, and best example, of course, would be fire codes and building codes, we have to make sure you have access, and under H.R. 1631, you will have access to all of this information for free. On the other hand, there's a considerable amount of cost that these standard organizations, often nonprofits, and others put into preparing and making available this information. They often do so in a form that is well worth a small price that is paid for either a printed book or an organized search capability. So what the bill does is it requires that this information be fully available to any and all. However, if you want to use it for commercial purposes and you want to have the advantages, then you can pay a fee. This strikes a balance where, for example, the homeowner wanting to comply with fire laws or building laws in their building can simply go online and make themselves available of all of this. On the other hand, the contractor who wants to take a series of books out to the site or have his notebook have a full copy of it to be able to refer to at any time would certainly and has historically been willing to pay a fee for it. This has had some history of court problems, but mostly it is an example of where my subcommittee looks to find ways to strike a balance to encourage and promote the useful copyrights, in this case, these works, while recognizing that the public, when it is an essential piece of information, has a right. I have coined the phrase for this and others as standard essential copyright, and similar to standard essential patents, you do not always get the ability to have something free just because it's in a standard, but you cannot and should not be denied access to it. That is exactly what this bill does. It is non-controversial, and I'm proud to say it is equally bipartisan with more than 10 members of this committee, more than 5 on each side, co-sponsoring it. I do understand that there may be amendments offered. I haven't seen them and was quite surprised to find that there might be. We're certainly willing to look at and consider and enhance the bill, but let there be no doubt, if we do nothing, we are certainly continuing a situation in which both sides are by definition unhappy, and our courts may continue to consider alternatives, but those alternatives do not strike the constitutional balance that we are mandated to do so. So I'm thrilled that this committee has come together on this bipartisan legislation, and would hope that we could get it out of committee today and continue to move it through its process. And with that, I thank the chairman and yield back.
Gentleman yields back. The chair now recognizes the ranking member, Mr. Nadler, for an opening statement.
Thank you, Mr. Chairman. Mr. Chairman, the Pro Codes Act is sensible bipartisan legislation that strikes a balance between copyright protection and public access to information. Sensible and bipartisan are not words that people often associate with Congress these days, but the Pro Codes Act fits that bill. Standards Development Organizations, or SDOs, are organizations that develop and publish standards to govern certain highly technical industries. These best practices govern everything from consumer safety and household utility installation to home electrical, wiring, and plumbing planning. SDOs make sure that your house won't catch on fire, your plumbing is up to code, your water boiler is installed correctly, and everything in between. You rely on your local contractor, and your contractor relies on their SDO standards. Very often, state and local legislatures, which generally do not have the requisite experts on staff to write highly technical standards, choose to incorporate SDO-developed standards by reference into the law. When SDOs come together to set these basic rules of the road for their industries, they are naturally entitled to a copyright for the content that they produce. And in cases in which a local, state, or federal legislature wishes to adopt that content into their laws, that should not mean that these copyright protections just go away. SDOs fund their work by selling their copyrighted material to other experts who can use it to make the necessary evaluations, repairs, installations, and the like. With this rigorous development and dedication to constant improvement, it is no wonder that states and localities want to adopt these codes by reference into the law. The only problem is, if you can't find the code, you don't know how it will affect you. And Americans have an essential interest in knowing that they can access the laws that govern them. So we find ourselves in a dilemma. Once the code is enacted into law, Americans must have access to this information. On the other hand, SDOs fund their work, which we rely on to keep us safe, through sale of their copyrighted works. If the reward for writing high-quality industry standards is to have your copyright taken away, this will undoubtedly have a chilling effect on innovation in these fields, and we also have an interest in ensuring that these codes always reflect the highest possible standards. The Pro Codes Act seeks to find the middle ground between these two competing interests. This legislation would allow SDOs to retain their copyrights when their standards are incorporated by reference into the law, so long as they make a copy available online at no cost. Under the bill, they could still put their code in a book or an easy-to-use app and sell those products to their members and related companies. This would ensure that it is still financially viable to continue to innovate and to update and develop these codes. But at the same time, the standards would have to be made available online for all the world to see. There could be print controls and copy controls, but the law would still be publicly accessible. As I said at the outset, this is a sensible bill that would help trade associations, the American public, and our innovation system. And I appreciate Mr. Issa and Ms. Ross for introducing this legislation in a bipartisan fashion. But I must note that there has been no hearing and no process on this bill before today's markup. Legislation on a complex subject like copyright that affects so many industries within the standard-setting community and that must be balanced with a strong public interest would benefit from greater stakeholder input and greater deliberation. While I will be supporting the bill today, I hope that there will be an opportunity to further refine it before it advances further through the legislative process. In particular, I want to call the committee's attention to a letter we received yesterday from the American Society of Mechanical Engineers, the Institute for Electrical and Electronic Engineers, the American Welding Society, and the National Board of Boiler and Pressure Vessel Inspectors. These are organizations that support the intent of this legislation, but may require a handful of technical corrections before this new standards regime can work for them. There is certainly room to accommodate these concerns on the way to the floor, and I ask unanimous consent that this letter be made a part of the record.
Without objection.
With that being said, I urge members to support the bill, and I yield back the balance of my time.
Gentleman yields back. Who seeks recognition? Gentleman from Arizona is recognized.
Thanks, Mr. Chairman. I've listened to the bill's sponsor and the ranking member trying to listen very carefully. And I'm left with a couple of questions, and I think maybe the California representative might be able to answer. Number one is, what is the problem this bill's trying to fix? Number two, what is the impact of where this is going? And number three, as a former state legislator, I'm trying to understand what impact you will have on state legislatures that actually do look at these standards that are and incorporate those into their statutes. And so I'd like to know the answers to those three questions, please.
If the gentleman would yield. The gentleman has very apt questions, and this is something that I'm glad he asked. First of all, if copyrights are put into standards and no copyright protection occurs, and some cities and states have felt that it's that way, then what you end up with is third parties taking the copyrighted material and monetizing it with no benefit to the copyright holder, or simply rampant production of it, which eliminates any ability to charge. If you lose...
Can I ask you a question on that point? Are you saying then that if the state legislature incorporates by reference, which quite frankly, all of these organizations bring their proposed standards to us when I was in the state legislature, they begged us to adopt those standards. Are you saying then that the legislature then, in order to protect their copyright, we have to pay royalties, or what is that about?
You're exactly right. Clearly, we want to make sure that the material is available royalty-free. But as you can imagine, the legislatures, and state legislatures are exactly where this happens, they make a decision to either research and pass their own legislation, and complex legislation such as what the standards should be for boilers or fire codes and so on would not occur easily at the legislative level. The expertise doesn't exist that way. Paying an organization to develop it for you and then owning it by the state would be a cost to the state. Instead, these not-for-profit organizations use the revenue they receive from those who buy their books and so on to help offset their cost of their members producing these standards. It is an example of a public-private relationship. It is well established. It's been around since before you and I were born. What we're trying to do is make sure that in all cases, the public has a right and an ability to go online, see the information, know what it is, while preserving the ability for these not-for-profits to gain the revenue through their sales that allow them, normally to architects and professionals and so on, that allow them to have a revenue that offsets their cost. And again, their costs tend to be very small compared to what a legislature would have. And in looking at this, and many of those who asked for some time to make technical corrections are exactly the organizations that, in a not-for-profit situation, are creating the standards that legislatures then adopt rather than trying to reinvent.
So, reclaiming my time, in my experience, these standards that come to the state legislatures, they seek, these organizations seek actual nationwide adoption. So Arizona and California, they want us all to be on the same page. And so they bring them to us, and I don't know of a single legislature that's actually out there saying we're going to bring in experts and develop our own. They're relying on these. Okay, we get back to my original question, what is the problem? And if I understand what you just said is that somehow if the state adopts and incorporates by reference or puts it into their code in and of itself, that somehow that eats away at the copyright
Well, what happened?
of the producers? Is that what you're
If the
saying?
gentleman would yield, if we strip away the copyright, then they get no revenue.
Who's stripping away the copyright, sir?
Well, this is the position of many individuals who say, quite frankly, you're passing a law, but you're denying me the free access to read and comply with the law. There is an inherent right for someone to be able to, at no cost, be able to see the law.
Right.
And in the old days, we might have said, well, there's a copy in every library. Today, we effectively say, no, it's got to be available online in a way in which the public can access it. That's what this bill seeks to do. Now, if I can, the history is that these organizations were formed at the behest, quite frankly, of legislatures to do it, to create it. As in an ongoing basis for us in state and federal legislatures, of course, there's a dialogue of, oh, here's the newest update, here's something, but that's decades or even a century after these organizations began producing them. The questioning of their copyright has come where we're trying to strike that balance. Clearly, if they get no revenue, they will go out of business and will be forced to try to make laws over which we don't know. On the other hand, if the public is denied free access to see the law, then they're not given an opportunity to obey the law, but rather being forced to pay to obey, and that would be wrong too. I thank the gentleman.
Time of the gentleman has expired. The gentlelady from North Carolina is recognized, and then we'll come to.
Thank you, Mr. Chairman, and I move to strike the last word.
Gentlelady is recognized.
Thank you. I'm pleased to co-lead this bill alongside Representative Issa, continuing our bipartisan work on patent and court issues that we began last Congress. And we had a good law we got passed last Congress through this committee. The Pro Codes Act is a common sense solution that balances providing free public access to codes and standards that have been incorporated into law while ensuring that important code development work can continue. And Mr. Biggs, at the end of my comments, I'm going to try to answer one of your questions. The industry codes and standards that keep us healthy and safe every day are created by standards development organizations, or SDOs, which regularly convene experts to write and modify standards and ensure electrical codes, building codes, crisis management codes, and more are up to date. Importantly, the standards that SDOs put out are approved by consensus and adopted by industries voluntarily. However, Congress and federal agencies have recognized repeatedly that governments should rely on these standards whenever possible, which has led to their incorporation into law, including state law. I firmly believe that codes that have been incorporated into law should be available to the public at no cost, as Mr. Issa has represented, and these would be available online for free. That's why this bill requires the codes be available online, which is not the current law. That said, code development requires revenue, and SDOs cannot operate without funding, and they earn that funding by maintaining copyrights to their codes as works of original authorship, which allows them to sell print copies and subscription access to the codes to fund code development at no cost to taxpayers. These purchased formats are typically used by builders, electricians, and other professionals who regularly refer to these codes in their line of work and do not want to rely on the read-only web page. Ultimately, this bill strikes a critical balance between enabling public access to codes incorporated into law and ensuring copyrights are protected and able to provide revenue to organizations that create and update the standards we need to stay safe and healthy. And I hope, Mr. Biggs, that that answers your question, that this would, you could put a link into a legislature's website or state law that just goes to the read-only code, so anybody can see it at any time for free. The legislature doesn't have to pay for it. It's other forms that would cost money. And then finally, some of the issues that have come up have come up in the last 24 to 48 hours. I want folks on both sides of the aisle to know that we stand ready to work with Congressman Issa and any others to make any necessary technical changes to this bill, either in the Rules Committee or as it comes to the floor. We have no intention of leaving stakeholders out. And with that,
would
Mr. Chairman,
would my colleague would my colleague yield for a question?
Yes.
Colleague from North Carolina. So, you know, I think of the situation, for example, the North Carolina Building Code is also, it's incorporated by reference. It is a code that's promulgated by the International Codes Conference, I think. And if I were to go look at any other law, I could go to the General Assembly's website in North Carolina. I could search the code. I could pull up the law. I could copy and paste off of that. I notice if I go to the International Codes Conference website, I can read the portions of the North Carolina Building Code as this example, but I can't copy off of it and paste. I cannot search it. That is all premium content you'd have to subscribe for. I don't know if these things vary, but when you say reasonable access, this law doesn't really seem to define that, except it's read-only access, it appears to me, meaning that you can do what I just described. Different than what I could do on the website of the General Assembly. I can't copy, I can't search for words or terms. Is that correct? And is that what the balance is that's struck by this bill?
So the balance is that it would be required to be free in this read-only format. The complicated thing here is that we in Congress and state legislators do not want to fund the development of these codes.
Yeah, I understand that.
And these codes do have a copyright. And so if the people who develop it cannot get any revenue for doing that, but have to provide it for free, then they absorb the cost of that. And I will also yield to Congressman Issa if he wants to add anything to that. But that is the problem we are trying to solve with this bill, creating that balance.
Mr. Chairman?
The gentlelady's time has expired. We'll go to the gentleman from Wisconsin and then to the gentlelady from California.
Thank you, Mr. Chairman. I'm proud to co-sponsor my colleague, Mr. Issa's bill, H.R. 1631, the Pro Codes Act, and I hope that we would pass it today. When folks across my state go to bed tonight, they feel protected from electrical and fire hazards because of standards developed by experts across these fields. These standards development organizations, or the SDOs, convene experts across industry to develop and publish a variety of technical and other important safety standards for use by both the public and private sector at no cost to taxpayers. However, federal courts have endangered these organizations' copyright protections by ruling that SDOs lose the benefit of copyright for their safety standards when they are incorporated by reference into law by federal, state, and local governments. This puts public use of these important standards in jeopardy. H.R. 1631 makes a small but important clarification by stating that SDOs retain copyright protection when a standard is incorporated into law or regulation, provided that the standard is available for free viewing on a publicly accessible website. The bill strikes a balance between the needs of the public and the needs of the copyright owner. And importantly, this bill does not preclude SDOs from licensing copyrights on their standards, which are necessary to support the organization's standard development activities. I want to thank the gentleman from California for introducing the bill, and I urge its passage, and I yield.
Would the gentleman yield for a moment?
I do.
Thank you. You know, the gentleman makes a wonderful case of the balance that we struck. And I might note, because there seems to be some confusion, that standard setting, for example, the industry I came from, the electronics industry, every one of us that has used a Wi-Fi port or has ever had a DVD or even streams today, those are standards. Those standards, such as the ones that the FCC adopts, those standards are codified in law. And in fact, we look at, for example, the Wi-Fi and say, well, we're using it for free. Isn't this great? We are. But those who make the products pay a standard essential patent license for often many, many, many patents that go into them. So again, that's a similar example where we realize that we have to reward those who innovate, who create something, and while at the same time providing for the common good. This is a very similar balance, a balance between rewarding those who created the content, but not penalizing those who use it, and that's exactly the same way. These individuals' copyrights, when incorporated, whether by their choice or not, will in fact lose part of their normal copyright protection. But the example given earlier of cut and paste is a good example. Limited cut and paste probably wouldn't be a problem and could potentially be incorporated, but let's understand, printing a book or downloading the entire content is not something you get to do without going to LexisNexis or some other search engine. So even in other laws that the gentleman mentioned, we do see that there are people generating revenue, and once they create that database or that search engine, they expect to be compensated. So hopefully, and I appreciate the gentleman co-sponsoring it and understanding it so well, hopefully this will be an example where there may be technical corrections. I know the chairman is perfectly willing to not have this go to the floor without both sides weighing in on final technical corrections. But hopefully we all understand that striking the balance, as we do in standard essential patents, in these copyrights is important for the continued production of this kind of material, which currently occurs at no cost to the governments that often adopt them. And I thank the gentleman.
Would the gentleman yield for a question? Would the gentleman yield for a question before yielding back? Mr. Issa?
Sir, of course, I'd love to hear it.
Mr. Fitzgerald.
I beg your pardon. Mr. Fitzgerald, thank you. Then maybe the question goes to Mr. Issa. Does this statute respond to some new case? That's one, does it overrule some significant decision in law that would, because I know this has been an issue for a long time. For example, as a lawyer earlier in my career, I can remember that there was litigation, like Westlaw is the big, now it wasn't even electronic at the time. Well, it was, but they would publish law, and then there were cases over whether that could be copyrighted. And then they said the editorial enhancements could be, but not the law. Is there some new decision that this overrules?
There are a number of cases, and of course they vary from state to state, where there's copy and paste going on, where these SDOs are litigating, sometimes winning, sometimes losing, and we'd like to create a single predictable standard for both sides. So yes, there have been a number of them, and of course they're occurring at the state level, and we want to have a harmonized one because it is our responsibility. I appreciate the gentleman. I thank the gentleman from Wisconsin for yielding to both of us. Yield back.
Gentleman's time has expired. The gentlelady from California is recognized.
Move to strike the last word.
Gentlelady is recognized.
I strongly object to this bill. It runs counter to longstanding Supreme Court precedent that recognizes that all citizens should have free access to the content of the law, and it also poses, I think, serious constitutional concerns that have recently been noted by the U.S. Court of Appeals for the District of Columbia Circuit, permitting private ownership of standards that are essential to understanding one's legal obligations. I'd like to ask unanimous consent to put into the record an article, "Bill in Congress would bar Americans from deciding our own laws."
No objection.
Starting with the case of Wheaton versus Peters in 1834, when the Supreme Court decided that no one could copyright a court decision, there's a long line of decisions that you can't copyright the law itself. Most recently, in a case in the DC Circuit, American Society for Testing versus Public Resources Organization, they said this: a serious constitutional concern with permitting private ownership of standards essentials to understanding legal obligations. As a matter of common sense, access to the law cannot be conditioned on the consent of a private party. That was confirmed by the Supreme Court when Justice Roberts affirmed, saying no one can own the law. Now, this bill would overturn those legal decisions that are recent ones, barring citizens from reading, and I would say also disseminating laws without a license is completely contrary to our concept of of law where citizens own the law that we make, not some private entity. Now, I understand that the chairman thinks that this has been satisfactorily resolved by allowing people to view a web page. That is insufficient. If we want robust debate, and in order to do that, for people to argue about standards, you have to be able to disseminate them, to argue about them, to critique them, not just to a view only. And I would note also that some of these standard organizations, having been pressed by the courts to make this information available, are now doing it, allowing it only if you give up your private information, you register with them, you give them their data. Never in the history of this country have we required citizens to give up their personal data in order to look at, understand, and argue about the law. This is a complete departure from the history that we have in our proud country. I would note, and I would ask unanimous consent, that the amicus brief that I wrote and filed with the District of Columbia Circuit Court be made a part of this record. In that brief, I note that our own laws, our Open Government Data Act, requires not only that it be open, but that it be shareable, that it be machine readable, so that the citizens can have complete access to government information. And I think that standard that we have placed to all federal agencies about information should not be denied people seeking access to the laws that are incorporated by reference. I would ask unanimous consent that we
Would the gentlelady mention who wrote that brief?
I submitted the brief with the help, as we always get, from outside lawyers. In this case, Jeff Perlman, the Intellectual Property and Technology Law Clinic from the USC Gould School of Law. I would note that we won this case, that the law is free today. This bill, which I wish we'd had a hearing about it because I could have made my objections known at that time, this overturns not only the recent win for freedom, for access to the law, but it is contrary to the entire history of the United States that allows citizens access to the law, to own it, to disseminate it, to argue about it, and by giving the ownership of the law to a private party, it's completely contrary. But going back to my unanimous consent request, it's a letter sent by the Electronic Frontier Foundation, Public Citizen, Public Knowledge, Demand Progress, the Internet Archive, Library Futures, the Authors Alliance, and several others, with a memorandum outlining the serious problems with this bill. I see my time has expired, so I will yield back, but I have a series of amendments that I will offer to try and fix this.
Gentlelady's time has expired. The gentleman from, I think the order was Mr. Bishop from North Carolina.
Thank you, Mr. Chairman. I hope to ask a series of questions. And I will tell you that coming to this hearing on this markup on this bill, I've been troubled because I've had some advice to be concerned about it. I'm familiar with it from my own legal practice over time, but I'm not an expert on the law that Ms. Lofgren cites, and I want to make sure I understand it completely. I'll also say I tend to be sort of in the middle of the road on this. I do think standard-setting organizations ought to be able to operate as they do to formulate standards. Those ought to be able to be incorporated into law. There ought to be reasonable access to them for people who are not practitioners, but it has always been true that there are editorial enhancements and sophisticated functionality in Lexis and Westlaw as examples that can be copyrighted even though the law cannot.
Correct.
And I think the question is what is the right level of access? And so I'm taken in part by Ms. Lofgren's argument just now, but I'm not sure what constitutes going too far. It seems to me, and perhaps I'll ask the gentlelady, or yield to the gentlelady in a second if I can formulate this to see what the problem is in her view, But if the information is available on a website, and again, the problem I have is the one I've just happened to pick out is International Codes Council. They've got it set up so that you, and frankly, the costs, I will say, are quite modest to get a subscription even to their further access, but you can go and look at it. It seems like you ought to be able to function like a normal web page, ought to be able to take, cut and paste information from it, ought to be able to do a basic search. But, more advanced stuff, if there are annotations of cases, if there's editorial content like headnote systems that we're familiar with from legal cases, all of that ought to be copyrighted, it seems, copyrightable. And it provides a value for people to have an incentive to produce it for the purpose of advancement of whatever the art in question is. So I'd yield to the gentlelady from California if she would care to speak on that a moment. I'm trying to get better clarity.
I thank the gentleman for yielding. Yes, these standard-setting organizations, many of them produce manuals that help people comply with it. That's copyrightable. That's not the law. That's it's similar to LexisNexis. I mean, you can't copyright the decisions, but you can copyright the critique of the decisions, or it's the same thing. The problem here is that you go to a website, let's say you're a civil libertarian and you disagree with part of a building standards. You should be able to copy that, to publish it, to have discussions with others of like mind about that. You can't limit debate and understanding of the law.
I'm trying to narrow it. If you could, if I can give a link to the website where the whole code can be read, how is it better to copy it and distribute it?
Well, we've never allowed a private party to own the law.
I understand the issue, the basic issue there. Let me ask. My colleague from North Carolina is sort of shaking her head. So see all the dissension on the Democratic side I can create. I'd just like to yield to the gentlelady from North Carolina to see if she could get at what I'm trying to ask.
So first of all, I want to express my great respect for my colleague, Representative Lofgren. She is a brilliant legal mind, and I hate to ever disagree with her.
I don't mind that.
But I will say this, and the question is, how did this code come into being in the first place? And private parties created this code. So it's not like when you go to court and there's an open court system.
I agree.
So here, private parties have created it. And some states have adopted it, or the federal government has adopted it. And the federal government is not compensating that private party for it.
Right.
In this case, the private party would make it available for free.
Let me reclaim my time, because
in a certain sense, it's a taking.
I get it, and I sort of agree with that. I also sort of agree with Representative Lofgren. I think the question is, what is the correct balance? I think you ought to have access that is similar to what you'd expect on a conventional web page. You probably ought to be able to search it, basically. You probably ought to be able to copy and paste some of it. Otherwise, I don't see the problem. And so I'm out of time. Thank you. Well, not quite, but 10 seconds. Let me just say this. I just think, I'm not sure the bill strikes the right balance as it is. I think it might need to be modified a bit, but at least in my view, I don't take the extreme view on either side. I think there are public interest concerns, freedom concerns, but I think you ought to have some ability to have a private standard-setting body compensated in effect for that function, as the gentlelady from North Carolina says. I yield back.
Gentleman yields back. I think we have Ms. Jackson-Lee, then Mr. Ivey. Ms. Jackson-Lee.
Thank you very much, Mr. Chairman. I asked to strike the last word.
Yeah, we will, but I'm just, excuse me, I'm sorry. Gentlelady is recognized.
Thank you so very much. I would say to Mr. Bishop of North Carolina, you have not created dissension on this side of the aisle. You've simply created an uplifting of mutual respect for all of the members on this side of the aisle. We engage respectfully with each other. But let me try to ascertain or to ascertain the reasoning and then establish my basis for recognizing this legislation. As I say that, I always believe that my friends are correct, that hearings are always a preferable approach than a direct ride to markup. But I'd like to give some sense of my interpretation that warrants the passage of this legislation and maybe more work before we go to the floor. These codes specifically are made by the National Fire Protection Association. This is their intellectual work. These are standards that are important in making the world safer for everyday citizens and for the firefighters throughout Texas and around the nation. In fact, they rely upon them daily. They have access to them. There is governmental access to this for free. States and cities often use the NFPA's safety standards for many purposes, including through incorporation by reference to protect people and property. And my sense of it is that they can open their handheld technology, they can access it in their office. The NFPA uses rigorous consensus-oriented American National Standards Institute processes to ensure that all interested parties can provide input into developing high-quality standards that evolve as information technology advances around this whole issue of firefighting. And this process is self-funded by the NFPA, meaning industry or other contributions cannot and do not influence the process. And that's where I want to rest my argument. My argument is that the governmental entities do not have to pay. It is copyrighted material. There is an in-depth investment of intellect and review of fire problems so that this organization can come up with the best practices for the architect, the builder, the builder-developer, the school district that wants to make sure their schools are safe. They have access to this. The fire marshals have access to this. And therefore, I feel comforted that there is not wrong kind of or wrong-headed influence in this process, which means to keep them standing on their feet and current and using the greatest technology in minds to make sure we have the best fire standards. We have seen fire death go down in some areas, but we have seen that we still have catastrophic fires. So it is important to be on the cutting edge. I think my friend from California's concerns should be represented, should have been represented in a hearing, and may be able to be entertained as we go to the floor. I always believe that any perfections that can be made should be considered. But I would make the argument that I want a freestanding National Fire Protection Association to provide my firefighters the best information on my fire marshals and the other persons who are in the private sector. I want them to be able to access as well, but a fee to keep the NFPA on its feet, from my perspective, is a worthy investment in this. I want to bring to the point of our members that the standards continue to reflect the most up-to-date knowledge and technologies, and NFPA updates its standards every 3 to 5 years using a very expensive process, which takes 2 years to complete. So, Mr. Chairman, I believe that this is a worthy bill for us to move, but not without taking into concerns of my colleague from California. I want to submit into the record this letter that was on City of Houston stationery, but it came from Samuel Pena, Fire Chief, City of Houston, Charles Hood, Fire Chief, City of San Antonio, Joe Baker, Fire Chief, City of Austin, and it goes on with other fire chiefs throughout the state of Texas. I ask unanimous consent.
Without objection.
I'd ask unanimous consent to put into the record the National Association of State Fire Marshals, dated July 18, 2023. Ask unanimous consent.
Without objection.
Previous letter was dated June 15, 2023, and then 2 other letters contributing to legislation that we've already looked at. A letter dated July 18, 2023 from the ACLU on the 4th Amendment. Ask unanimous consent.
Without objection.
And a letter dated June 26, 2022 with organizations like Muslim Justice League, Center for Democracy, Center for Human Rights, Constitutional Alliance, and many, many others. I ask unanimous consent.
Without objection.
On the underlying bill, Mr. Chairman, I would support moving it forward. I yield back.
Gentlelady yields back. The Israeli president speaks at 11. They've asked us to try to get to the floor by 10:30. We have 4 in the queue. I know some have been waiting, so I'm going to try to get to a few more of you, but we will break at 10:40 so that we can get to the floor for the important address from the president of Israel. So next is Mr. Johnson, Mr. Ivey, Mr. Gates, Ms. Hageman. If I can get to y'all, we will.
I'll be very brief. Quickly, I just wanted to note the presence of our esteemed former chairman, Mr. Lamar Smith, the gentleman from Texas.
Yes.
So he's in the back. There we go. Thanks for being here, sir. I just want to yield to Mr. Issa because he has not had enough time, I think, to address some of these concerns. But one question maybe that would get you started. It is a balancing test. I've kind of been with Mr. Bishop on this. I'm a little double-minded. I'm trying to sort it through. Is it true? Someone has made this statement, and I wonder if you think it's true. Is it true that without this copyright protection, the standard-setting organizations might be less incentivized or maybe even eventually no longer exist to function in this way and thus provide their valuable subject matter expertise so that, in that case, then the government itself then might have to assume that responsibility to create standards without all the subject matter expertise and thus expand its power, which is something that concerns me. What would you say to that? I yield to you.
The gentleman's exactly right, that if you take away any ability for them to find a revenue that these are nonprofits that pays for itself, then they would have to find an alternate way. And I think to your point, and a point that was made earlier, let's talk about the taking. The fact is that these standard-setting organizations could create standards and then say, you can't have them. You go ahead and write your own law, write an original law. We'll just have a standard that we'll have. And we could have a disconnect between standard setting, which they'd own the copyrights, and it would be best practices. And we'll use something like Underwriters Laboratory as an example, where you pay to go through and get your product there and get the little seal, completely private. It's not per se codified in law, and yet the government references the underwriters. Many places won't carry a product unless you have UL approval, but I got to tell you, it's not cheap to go through there. That's not a standard we want to have for fire. It's the reason that fire marshals and all kinds of organizations who are users of that have been telling us this system works, and the partial taking that this bill has, which means forcing them to provide for free access to it, in fact, is consistent with the law. As a matter of fact, Ms. Lofgren cited these earlier cases. These earlier cases were laws created by legislatures that you cannot deny. They are not by reference the way these are. But notwithstanding that, we believe, and we've pushed hard in this bill to try to strike a balance, which is there is a partial taking because this has to be available fully online. And quite frankly, for those who have worked with any of this, for a fairly de minimis amount, you can get a program, and then you can copy and paste and make your insertions. As a matter of fact, those who practice, architects and engineers and builders, they regularly buy this stuff so they can have very organized presentations when they want to argue for a particular what they believe is a compliance. Well, somebody maybe downtown at the building organization doesn't. So there are reasons in which you want to have that, but quite frankly, the enhanced capability is there if created. It won't be created if we simply steal their copyright, and by the way, the new material won't be created. But I think the gentleman has a very, very valid point, and I thank him for yielding some time.
Would the gentleman yield?
Let me yield to Mr. Gates and then Ms.
Yeah, I want to answer your question drawing on my 6 years in the state legislature. I believe that these standards organizations will draw their revenue as they typically have from their membership, right? So if you make a widget and you want that widget to be a part of the standard, you have an incentive to join the organization that is going to advocate for that widget to be a part of the standard. And that will be a sufficient incentive structure to continue to get that expertise. And the notion that if these folks can't charge for access to some of the standards they create in some way, that then people in the construction industry, in the fire safety industry are just going to say, well, we no longer care that the business, that we get to participate in the rules that govern the business we're involved in. I don't believe that would dissolve. I think that would still exist, and the government would still be able to draw on that experience in the absence of the expanded government that would concern my colleague from Louisiana.
Would the gentleman further yield so I can answer that?
Let him respond, yeah.
The reason that fire chiefs and fire councils and firefighters are all supporting this is not because of the widgets. There are widgets in some cases, but in most cases where we're really talking about a fire occurs and a standard gets updated to say, you know, you have to have a sprinkler so many feet from such and such, and you need to have certain amount of pressure. Those kinds of analysis of what happens, for example, in a fire safety situation, and the updated code, and the same, by the way, occurs in earthquakes and other construction. Those kinds of things don't have a product. They do have associations, but those associations, quite frankly, often would not have the revenue and would have no incentive of creating it. Thank you. I yield back.
The gentleman yields back. The time of gentleman's expired. The gentleman from Maryland is recognized.
Thank you, Mr. Chairman. Move to strike the last word.
Gentleman's recognized.
I want to circle back to Mr. Biggs' original point, which was sort of what happened, what led to a problem that needs to be fixed at this point. And as I listened, I think Mr. Fitzgerald said there was a court case that apparently had an impact. I'd like to know more about what that, or if there may be multiple court cases. I'd like to know more about what those courts ruled, what standard came out of them, and what it is we're trying to fix. And then to Mr. Bishop's point, I'm also a recovering litigator. If it could be sort of explained in the terms of, because I agree, so the Lexis piece, can't buy the law, you can get the comments and the like. If you have a treatise that's put online, that's a copyrighted document. And so you have the copyright for the document, but also for the comments that Lexis or Westlaw is putting in there. How is this different from that, I guess, is another issue that I just want to get a sense of what's the problem, what are we trying to fix, and how do we fix it? Because it seemed like apparently it had been working okay. Whatever the revenue stream that these entities got for generating these standards had been, and maybe still is, maybe they still are working, but something led to this legislation being required.
Would the gentleman yield for just a quick answer?
Would the gentleman yield?
I will yield to Mr. Issa first, and then Ms.
And I'll be very brief. You'll find multiple lower courts that have ruled that these standards are, that the taking and downloading in bulk was fair use. That often was reversed, but not without a fight. So that's one of the areas of great concern for these standard-setting organizations because, quite frankly, that litigation costs them to protect their own copyright, where normally a copyright holder would absolutely, when they won, get statutory damages and not have to go through this procedure.
Ms. Lofgren?
Yes, there is a recent decision from 2018 and we've entered it into the record. We'll make sure you get a copy of it on this very point. In fact, I submitted an amicus to that as well, where essentially those arguing that you cannot copyright the law prevailed. That was appealed, and most recently in the case of, in 2020 case, Georgia versus Public Resources Org, held that government published material is not copyrightable, and it was Justice Roberts who said no one can own the law. We will get you a copy of that as well.
You have a site for it, Zoe, by any chance?
Yeah, the district court for the appellate court in the District of Columbia and the United States Supreme Court. And we will get copies of both of them for any of the lawyers who want to read them.
I yield to Ms. Ross.
Thank you. I just, again, want to make this just very clear point about whether or not somebody can own the law. The question is, who created the standard in the first place? So when we talk about a court case, that is something that is in the public domain. It's something where everybody can attend. This is a situation where a private organization, privately funded, created a standard. The government then liked the standard and decided to shortcut, not pay to create its own standard, and adopted that. Here, the private organizations are willing to make that available. But if every time the government likes something that a private organization does and codifies it, that's a taking. There is no compensation for every time the government decides that a code a private code should come into the law. And that, I think, is the distinction between owning the law. So, of course, the world should see this.
Just to reclaim for a second, because I'm running out of time. I appreciate that. That's not the issue I had, though. The court case that I'm referencing was the one that apparently created the issue, because the approach that you just outlined apparently has been in place and running for years. So the question is, what's the change that led us to want to put in legislation to fix whatever the new problem is? Because I'm not clear on what the new problem is.
If the gentleman would further yield.
Yes,
the
ma'am.
standards organizations lost in court, and so they've come to Congress because they've lost repeatedly in court. And that's why we're here today. I thank the gentleman for.
All right, Mr. Chairman, I know we're running out of time, but I would join in the suggestion that others have made that perhaps a hearing or some kind of additional opportunity to walk through this be provided so that we'd have a chance to go through some of the particulars.
Time, the gentleman's expired. I think we've got time for one more, Mr. Gates. We'll try to get to Ms. Hageman, but we may have to.
Thank you, Mr. Chairman, and I associate myself with the sentiment of Mr. Ivey that on a matter of this complexity, where I do think Mr. Bishop, Mr. Johnson, and others are trying to strike an appropriate balance, that a more fulsome review of where to find this line might guide us to a bipartisan landing zone. But when I'm confused, I tend to be the flavor of populist who thinks that the populace should have access to the law without having to pay even a de minimis amount. And there are a few reasons why. Like, in the most extreme, like what are we going to hear next? Road builders saying that you've got to pay to know what the speed limit is so that we can fund more roads? I mean, that would be the absurd extreme on one side. And then I also don't think that just because an organization collaborates with the government, that every thought they've ever had, every work product they've ever had, every manual they've ever had is all of a sudden in the public domain. So I do think that there is a balance, but I strongly reject the premise of the legislation that in the absence of these organizations being able to maintain a property interest that they can externally financially exploit, that they will just dissolve and cease to exist and have no interest anymore. And as we've been in discussions among colleagues, someone asked me reasonably, well, a bunch of firefighters are different than a bunch of contractors. So if some firefighters came up with something that was a good standard for fire suppression, then we wouldn't want them to be subject to the same lens that we would have someone that created a hurricane tie down that they wanted in the state of Florida to be part of the building code. But I think that requires us to zoom out a bit. The whole premise for why something ought to be in a code or a law is because there is some public good. There is some public import to that. And the point that my colleague from California, Ms. Lofgren, made earlier that I would like to double stomp is the notion that proliferating these codes and ideas actually can yield better public policy through clash and discourse and debate and review and questioning, and whether that's the latest sinkhole technology or fire suppression. I'm reticent to support legislation that I think could be limiting of that type of collaboration, particularly on matters as important as like whether people are going to live or die in a fire, or whether or not when an earthquake hits, people are going to be safe as a consequence of the building codes. And I also worry about the litigation that this bill could spur that we're not thinking about. We've had some discussion of the litigation that brought us to this point, but in a world post this bill, could you be in an environment where people believed that they were engaging in, putting on a seminar about building codes or about fire suppression, and they start using things that then they're getting hammered in some intellectual property context for. So while this is complicated, what I think the public needs to understand observing this debate is the purpose of the bill is to maintain within a standard organization a property right that the courts have said they do not have. Correct. And it is to maintain that property right to personally, to financially exploit it. That is, I think, the premise, but I would yield to the gentlelady from California.
I thank the gentleman for yielding. I think, it's not correct that these various standard settings groups would fall apart absent charging the public for finding out about the law. For example, the American Society for Testing and Materials in let's see, I get the right.
Flip it around, right?
They had, and their executive was compensated $4,500,000. Their revenue was over $100 million, and it was made up of their manuals, training documents, other materials.
Yeah, we seem to be in the wrong business, Mr. Lofgren, but I'm going to reclaim my time to yield it to Mr. Massey.
So what are standards? Standards are things that are in common use. Like, and let's just take an example. You might be able to copyright the format of your font and the arrangement of things, but you can't copyright the rise and run of a pipe for proper drainage in your plumbing system. A 1/4 inch per inch shouldn't be copyrightable to start with. That's a notion. These are physics, these standards are, and they're in common use. So I think you do get to own the fonts and the charts and the graphs and all that, but you can't own the concept as it goes into law. This isn't the weaponization of government, but this is the monetization of legislation, in my opinion. I yield back.
Gentlemen,
Yield back.
Gentleman yields back. We will stand in recess until approximately 15 minutes after the president's remarks, and then we will be back as quickly as we can.